We begin this hour with the breaking news out of the nation's capital. The D.C. Circuit Court of Appeals has ruled former President Donald Trump is not immune from the criminal case involving his efforts to overturn the 2020 presidential election. Joining us now to break this all down for us, NBC's Ken Dilanian, Rebecca Roiphe, former assistant district attorney in Manhattan and a professor of law at New York Law School, and Andrew Weissmann, former senior member of the Mueller probe, professor and an NBC News contributor. So, Ken, what are the top lines of this ruling, this 57-page ruling that has a lot of information in it?
Good morning, Jose. It sure does. And it's worth noting that this is an unsigned ruling by a three-judge panel of two appointed by Democrats and one appointed by a Republican. So it's a unanimous ruling that resoundingly rejected all of Mr. Trump's arguments for why he should be immune from prosecution for acts as president. And it went back to sort of first principles that we are a nation of laws. It quoted from an 1882 Supreme Court decision that said all officers of the government, from the highest to the lowest, are creatures of the law and bound to obey it. And it also, the judges added that it would be a striking paradox if the president, who alone is vested with the constitutional duty to take care that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity. The opinion makes clear that other presidents throughout history have assumed that they could be prosecuted. And after all, President Gerald Ford pardoned Richard Nixon under the assumption that he would be prosecuted for Watergate crimes after leaving office. And it's also worth noting, Jose, that this is a case of first impression. This is the first time that a court has ever rendered this kind of ruling, because there's never been a former president who's been indicted before who's been able to make these sweeping claims of immunity. And now this court has rejected them. And now the question will be, of course, Mr. Trump is going to appeal to the Supreme Court. And the question will be, does the Supreme Court take this case? If it doesn't, we could see a trial in this election suppression case rather quickly, as soon as May. If the Supreme Court does agree to take the case, it could delay it a little more. It's also worth engaging with Donald Trump's response this morning. Mr. Trump said that if a president in a statement, he said that if a president is not immune, then as soon as he leaves office, he'll be prosecuted by his political opponents. That is a fundamental misreading of what our system of justice is in this country. That's more akin to places like Mexico or places in Latin America where the executive branch and the judicial branch are rife with corruption. In this country, the politics does not infuse the Justice Department. In fact, the Justice Department was very reluctant to pursue this case initially. It was only after the January 6th committee confronted the American public with overwhelming evidence that a special counsel was appointed and Mr. Trump was indicted. And there was nothing political about what Jack Smith investigated and what he charged here. Nonetheless, that is Mr. Trump's claim, Jose.
So, Ken, the options for Trump and his team is the Court of Appeals en banc and the Supreme Court, or how does that go?
Right. He can request an en banc hearing, but the court does not have to grant him that. And this is such a thorough opinion. It's not hard to imagine that they don't go in that direction and they say, take it up with the Supreme Court. And then the question is, we've heard several legal experts say this morning that they don't believe the Supreme Court will take this case. That's one possibility. Another possibility is they do agree to hear it, and that will delay further this case going to trial. But it doesn't mean that it wouldn't go to trial at some point this year, Jose.
And so, Andrew, just wondering your thoughts, what stands out to you the most from it? And I'm just actually reading as we read through it, and Ken was referring to this. The appeals court rejected all of the former president's legal perspectives and what he and his team claim, and it's four motions to dismiss the indictment, all four rejected.
I have two thoughts. One is substantive, and one is the procedure of what's going to happen going forward. Substantively, this is a unanimous body blow to each and every one of Donald Trump's arguments. It is a huge victory for the government and completely vindicates Judge Chutkan in her ruling. It affirms it in every way, shape, and form. The court calls Donald Trump's arguments irrational. In a brief quote for you, he said, at bottom, this is the court's opinion, at bottom, former President Trump's stance would collapse our system of separated powers by placing the president beyond the reach of all three branches. It describes the president's position as saying that a former president would be free to commit all manner of crimes with impunity, and it fundamentally rejects that in every single way. Now, turning to what can happen next, the court gives essentially Donald Trump 1 week and 1 week only to go to the Supreme Court. It says that it will issue its mandate, that is sort of handing the ball back to Judge Chutkan at the end of February 12th. So basically the morning of February 13th, a week from today. The only way it will not do that is if essentially one of two things has to happen: that a filing is made in the Supreme Court seeking review, which is by no means clear that that is going to be taken, because this is such a resounding victory in every way. But that's something Donald Trump can do. He can seek to have this heard by the Supreme Court, but the Supreme Court does not have to take it. The other way in which Donald Trump could try to stay this is by seeking the D.C. Circuit itself to rehear this. But the court says on that, there is no automatic stay, that the mandate will still issue even if Donald Trump seeks that, unless and until the D.C. Circuit says, no, don't do that. Meaning, essentially what they're telling Donald Trump is, don't look to the D.C. Circuit for assistance in staying this case. You really have to go to the Supreme Court. So all eyes right now should be on a filing that Donald Trump will certainly make in the next week, asking for Supreme Court review, and what the Supreme Court does, because it's quite possible they reject that quickly, and this case will be back on before Judge Chutkan.
Right. So if the Supreme Court does indeed in one way or another say, we're not going to deal with it, it's back to it, what Andrew, this would mean is that indeed this is what takes effect and everything goes forward in D.C. And does it have, Andrew, an impact on any other of his courts? I mean, we're thinking Georgia. He's been, claiming some of the same things that he claimed here in D.C.
Yeah, it won't have an effect on the Manhattan case or the Mar-a-Lago, Florida case. Why? Because those are not, those are charges that are either before Donald Trump was president or after Donald Trump was president. So this whole claim of immunity doesn't apply, because the conduct is not for anything that was, the gravamen was not something that he did while he was president. You are right that with respect to Georgia, this decision knocks that out as well, saying there is no presidential immunity for criminal conduct. And it could not be more resounding in its language. And it also, as you've noted on page 39 and 40 of the decision, makes clear the court's view of the charges here about the president being charged with undermining fundamental democratic processes and values. It makes sure it says these are allegations. They remain to be proved, but it's clear that if they are proved, it views this as the most serious criminal conduct one could imagine anyone engaging in, let alone a former president of the United States.
And Rebecca, I mean, in this very detailed description, the appeals court goes into case law after case law, and specifically issues that dealt with the separation of powers. What is the signal you think, Rebecca, that it's saying that this ruling was unanimous?
I think it's an important signal. It's a signal that reaffirms this notion that the criminal justice system isn't in the hands of the administration or the current, democratic or political control, and the judges and the judicial system the same. So essentially, it's a battle between two different visions. President Trump's vision, where he can control the prosecutors who work for him and they do what he wants him to do, and the judicial system is run by judges who are either Democrats or Republicans and do what's in the best interest of their political party, versus this court and prosecutors who have been consistently affirming that our country works in a different way. We have an independent judicial system that follows the law, and we have an independent prosecution that also applies the law fairly. And so I think in this situation, you have the court voting for its view as opposed to the former president's view. And I think his strongest argument was that, well, what will happen if a former president steps down and then all of these opponents go after him? And the way the court rejected that argument was to say, first of all, we have things built in to prevent that from happening. Second of all, we don't feel that the criminal justice system works that way. It is not politically motivated. And I think that's an important message to take out of this opinion.